Correct.
So let me, on behalf of the Dean...
not yet. Not yet. You'll be called. Yeah.
Excellent.
Good afternoon, everybody. A very warm welcome to each of you, and thank you for joining us for the 2020 Julius Osega Memorial Lecture. We are delighted to host you this afternoon, and we look forward to an excellent session. This lecture is organized by the University of Nairobi, the University of Ghana, and the Center for Human Rights of the University of Pretoria. As is the norm, the Julius Osega Memorial Lectures provoke contemporary discussions on human rights. And this year's theme is Governance and Human Rights in Africa. So welcome to this session. And to start us off, I'd like to request the Dean of the School of Law, University of Nairobi, Professor KwadwoAppiagyei-Atua, to give us the welcome remarks. Welcome, Prof.
Thank you. Thank you so much, Dr. Sarah Kenyajui. Thank you, everyone, for joining us this afternoon. I'm greatly honored and pleased to welcome you to this year's Julius Osega Memorial Lecture that is hosted by the University of Ghana, University of Nairobi, and the Center for Human Rights, Faculty of Law, University of Pretoria. This memorial lecture could not have come at a better time than now, when we are not only marking 10 years of the Kenyan Constitution, but we are also celebrating 50 years since the establishment of the School of Law of the University of Nairobi. It is worth noting that last year, we marked 20 years since the establishment of the LLM program in Human Rights and Democratization in Africa, hosted by the Center for Human Rights, University of Pretoria. This year, again, we are marking 19 years since Julius Osega graduated from this transformative human rights program. It's also only 2 years ago that we celebrated 70 years of the Universal Declaration of Human Rights in 2018. As we mark these important milestones, this memorial lecture gives us a good opportunity to reflect on the transformative work that Julius Osega undertook, as well as how his legacy can enrich the promotion of human rights. In doing so, we shall be able to identify gains that we can build on, as well as challenges that we need to address. Apart from generating research-based knowledge, we, as scholars, also have a responsibility of ensuring that the research we generate feeds into the training of transformative human rights defenders, as well as leaders. We have seen the academia taking a leading role in the successful moral campaigns against slavery, colonialism, apartheid, xenophobia, and the ongoing George Floyd campaigns. We believe that the academia has a critical role to play in promoting human rights, and at the University of Nairobi School of Law, we continue to teach and conduct cutting-edge research in human rights with a view to shaping global human rights policies and practices. We know that Julius Osega did not shy away from danger in his efforts to promote human rights and democracy. And as a result, his legacy shall continue to be an inspiration to us. We trust that this memorial lecture will be a highly educational event that will not only help us enhance our zeal for promoting a culture of human rights, but also transform us into critical agents of African development. We truly value your participation in this memorial lecture. Thanks so much for taking part, and enjoy the discussions. Thank you.
Thank you very much, Professor Mwaura, for those welcome remarks. May I now invite Dr. Bassett. Dr. Bassett is representing the Dean, University of Ghana. Welcome, Dr. Bassett.
Thank you so much, Sarah Joanne. Let me first apologize on behalf of the Dean of the School of Law, University of Ghana, who is unable to join us today because he has to attend a very urgent academic board meeting, which is taking place at the moment. But let me say that on behalf of the Dean and the School of Law of the University of Ghana, I welcome everybody to these lectures, the Julius Osega Memorial Lectures. As has already been indicated, this lecture couldn't have come at such an opportune moment with the global COVID-19 pandemic. Issues of human rights definitely are going to come to the fore, not only in Africa, but in other parts of the world. In Ghana, we are heading towards our December presidential and parliamentary elections, and usually during times of electioneering, issues of human rights as a result of political contestations do come up. So it is our hope that the work and the legacy of Julius Osega in terms of his passion for human rights and work for human rights will inform and inspire all of us as we deal with the various challenges that confront us today. Let me indicate that the School of Law at University of Ghana has made human rights one of its core programs. In fact, for so many years now, in order to imbibe the spirits of human rights, not only in our students, but also to carry out the message of human rights. We established a human rights center which seeks to promote the values of human rights. The school has also been extremely active in terms of extending human rights consciousness.
We seem to have lost Dr. Bassett, but thank you for those remarks, Dr. Bassett. May I now welcome Professor Franz Foyen. I'm sure I'm massacring his name, but he will forgive me, from the University of Pretoria to introduce the 2020 Osega Memorial Lecture. Welcome, Prof.
Thank you very much, Dr. KwadwoAppiagyei-Atua. So maybe I also do return the favor. I try my best to also obey. So just to welcome everyone again, it is really a privilege for us at the Center for Human Rights, University of Pretoria, to be involved in this event. As I think everyone has learned, this event takes place within the framework of the Master's Program in Human Rights and Democratization in Africa, which is presented by 13 law faculties across the African continent. This program is also part of what is termed the Global Campus of Human Rights, which is really 7 similar master's programs across the globe, which are all to some extent funded by the European Union. Now, 3 of the universities, 3 among the 13, are obviously involved in today's event. University of Ghana, University of Nairobi, and Professor Mwaura, congratulations on the 50 years celebration also this year for the School of Law. And then lastly, also obviously the University of Pretoria. Julius Osega was a student and a graduate of this master's program. He attended in the year 2001, which was the 2nd year that program was, or this program has been running. So the day's lecture commemorates his life and the fact that also he passed away subsequent to completing his studies in 2001. Before he came to the University of Pretoria to do his studies in this master's program, he studied with another partner among the 13, and that is Makerere University. He returned after his studies to the Uganda Police Service, where he was actively involved over a number of years. He was promoted to the head of the Human Rights Complaints Desk, a position that he held until he was deployed to Darfur as part of the African Union force in Darfur. He was also the acting commissioner for the legal department of the Ugandan Police Service. Julius was regrettably killed on 8 July 2008 while he was on patrol in Darfur. He was serving there as part of the United Nations African Union hybrid force, the UNAMID peacekeeping force. His contribution to human the fact that he was prepared to really serve the cause of human rights, as it were, in the trenches, is something that we involved in human rights and the cause of democratization in Africa treasure very dearly. His contribution will be remembered and is being celebrated today. In Uganda, he is particularly remembered also for his efforts in addressing allegations of human rights violations by the Ugandan police force. And that is an aspect, I think, that in the context of COVID-19 also resonates again with us today. Now, many graduates of this master's program end up in academia and civil society, but very few end up in the security services. In that sense, what Julius did after he graduated really gave us great pride, because it also shows and it underscores what the master's program tries to achieve, namely to make a difference where the realization of human rights is sometimes the most precarious and the most difficult. So it was in the light of these factors and after the death of Julius that the partners decided to establish this annual memorial lecture in the name of Julius Osega to remember his role, to remember his personal sacrifice, but also to celebrate again the values for which he was prepared to also sacrifice his life. So with those few remarks, it really is a privilege to be with you this afternoon. We look forward to this lecture. We are glad that great academics agreed to be presenting the lectures. I might just in conclusion note that in the past series of lectures, we had illustrious figures like the Deputy President of South Africa, Motlanthe. We had the Chairperson of the African Commission, Solomon Darso. And we should note that this is the first time that the lecture is presented virtually. So it's certainly a historical occasion. Welcome everyone. Thank you very much. Let us remember and celebrate Julius Osega.
Thank you very much, Prof, for that history. And just to say that the spirit of Julius Osega lives on by us having this lecture. And we are delighted to host this lecture today. May I now welcome Dr. Hammond, who's from the University of Ghana, to welcome the speakers. Dr. Hammond, please.
Thank you.
Are you there, Amma? Hammond?
Can you hear me?
Yes, we can. Thank you.
Distinguished ladies and gentlemen, the speakers for today's Julius Osega Memorial Lecture are Professor KwadwoAppiagyei-Atua and Professor Edwin Abuya. Professor KwadwoAppiagyei-Atua will speak on the topic, Forging an African Governance and Human Rights Identity in a Post-COVID World Order. Professor Atua is an associate professor at the University of Ghana School of Law, where he teaches public international law and international human rights law. He's also the representative lecturer from the University of Ghana on the LLM Partnership Program in Human Rights and Democratization, offered at the Center for Human Rights, University of Pretoria, South Africa. Professor Atua has a Bachelor of Laws degree from the University of Ghana, Legon, a Master of Laws degree from the Dalhousie University, Canada, and a Doctor of Civil Law degree from the McGill University, also in Canada. He was a postdoctoral research fellow at the Irish Centre for Human Rights in the National University of Ireland. He also quite recently completed his Marie Curie International Incoming Fellowship at the Centre for Educational Research and Development, Lincoln University, UK, where he conducted research on the topic, Building Academic Freedom and Democracy in Africa. He's a member of the Ghana Bar Association the Global Alliance for Justice Education USA, and an executive member of the Jacobs Abbey Global Institute for Leadership Studies, also in the USA. Professor Appiagyei-Atua has served as consultant for various intergovernmental and international civil society organizations. Distinguished ladies and gentlemen, the second speaker is Professor Edwin Abuya, and his topic is Governance in Universities, Embracing Rights of Learners with Physical Disabilities. Professor Abuya teaches at the University of Nairobi. He also taught at the University of Sydney in Australia, Ulster University in the United Kingdom, and Seattle University in the United States of America. He holds a Bachelor of Laws degree from the University of Nairobi in Kenya, a master's degree from the University of Cape Town, South Africa, and a Doctor of Juridical Studies degree from the University of Sydney in Australia. Professor Abuya is an expert in human rights studies and specializes in the rights of vulnerable populations, including displaced persons, those living with disabilities, and individuals at risk of statelessness. He has published extensively on Significantly, he has published several articles in the foregoing areas of study. His publications draw extensively on empirical evidence, and consequently, some of his proposals have been implemented by the government of Kenya and the United Nations High Commissioner for Refugees. Professor Abuya has also consulted for a number of local and international agencies in his areas of expertise. Distinguished ladies and gentlemen, Professor KwadwoAppiagyei-Atua and Professor Edwin Abuya. Thank you.
Thank you very much, Dr. Hammond, for that introduction. And we now are privileged to welcome the professors for the lecture. Professor Kwadwo, please.
Thank you very much for giving me the opportunity to speak on this platform. First of all, as we say in Ghana, all protocols observed. My presentation is to discuss the emergence of a new world order and Africa's place in it. So it seeks to discuss Africa's global marginality and lack of agency in international relations and its contribution to the development of international law. It asks the question why we are where we are today and how the post-Cold War order, which is shaping up, presents a golden opportunity for Africa to adopt a multifaceted agency approach to develop a soft power status in the new world order. And this is to be achieved, according to the presentation, through an alternative or radical governance human rights approach. First of all, let me define or give an explanation of what the world order is. The world order is considered as a period of history characterized by new configurations in world political thought and balance of power that defines how countries interact with each other and how individuals interact with the world. It usually comes about as a reaction to a far-reaching global disruption. So with the current happenings in the world, with the pandemic, there's the likelihood that a new world order is just around the corner. Now, when the post-Cold War era began, intellectually and politically, people began to speculate and to make attempts to determine the path and direction of a new world order. And I cite two scholars from America. First, Francis Fukuyama, who in 1989, on the thesis of the end of history, projected that there will be increasing homogenization of all human societies, regardless of their historical origins or cultural inheritances. And in the end, there will be mankind's ideological evolution and the use of Western liberal democracy as the final form of human government. So he was predicting a liberal order as the new way to go. A few years later, Huntington, on the other hand, went in the opposite direction in the clash of civilizations. And he projected that there would be any upcoming war will be fought not on ideological lines, but rather along the cultural fault lines separating one civilization from another. Now, if we review Huntington's works, he mentions certain civilizations as likely areas where this fault or this conflict may emerge. Interestingly, when it came to Africa, he only said that Africa's civilization is still coalescing, in quotes. And so in his view, Africa as a continent lacks a sense of Pan-African identity. Now, this is to be a rehash of Africa's a negation of Africa's historicity, that Africa didn't have history until its connection with Europeans later on in the world's history. And this is supported by one prominent scholar in international relations who argues that Africa did not have a history before the First World War, and hence it was a politically empty space. And consequently, African issues and those of the developing world are largely inconsequential in international relations. Now, Huntington was talking about the fact that Africa is of no relevance in the world order, therefore reinforcing the point of Africa's global marginality and lack of agency. So what is agency in international relations? It's basically the ability of a state or an international organization to negotiate and bargain with external actors in a manner that will benefit the former. And agency is about projecting a posture of power and self-help in international engagements. Usually, countries are able to project this agency elements based on a foreign policy to reflect such interests. And it is not only countries, as the work will reveal, but also international organizations. And this is where AU has been lacking and therefore accounts for part of our marginality in international relations on the world scene. This is not to say, though, that the general argument of Africa's global marginality has been challenged. Bayard, for example, argues that this is wrong because Africa has never existed separately from world politics. And this idea of international relations, saying that Africa is on the margins, doesn't have any history, is similar in, there was a similar claim when it comes to international law. And so every year when I have to teach international law to my students, I hack onto that as a starter. And I hear, quote quickly, Malcolm Shaw, who says, the foundations of international law, the law of nations as it is understood today, lie firmly in the development of Western culture and political organization. However, this position has been contradicted by scholars such as Yasuaki. Different bodies politic existed, and they developed primitive international laws within their geographical space, and which was used to interact among themselves. And therefore, the idea that international laws started in Europe and others didn't have it is completely wrong. This view is supported by Richard Smith, who says, it is true that frameworks of broadly similar customary law operated over wide sections of Africa. That makes it possible to speak of a system of African customary international law. Even though this person or this scholar is speaking from an international relations perspective, he's referring to the notion of the development of regional customary law as we have it today. For example, if you refer to the asylum case, those interested in human rights. Now, in the context of Africa, we had these political systems as well. And so one scholar makes the point, which is quite interesting to note, that one authority has likened the traditional African way of doing international business to that of medieval Europe. The two regions were similar in that neither had developed the modern concept of an international society composed of entities called states, all supposed to be equal, sovereign, and completely independent. In both areas, there was, by present-day standards, a good deal of international untidiness, unquote. So within this context, we can see that, yes, there was an African notion of international law, And there was also an African practice of international relations. And scholars from the realm of politics who deal with particular democracy have identified certain key elements of the democratic structures in African countries which support this argument. Christian Porton, for example, identifies 18 of such political systems in Africa and remarks that this plurality of forms and types were made possible by the fact that Africans, far from passively accepting the political systems, chose forms, altered them, and developed entirely new ones. And from a strictly human rights point of view, Timothy Fennihoff also argues that dissent, tension, confrontation, and struggle against tyranny and elitism were responsible for provoking change in traditional African political systems and for the development of a culture of human rights. So this is to make the point that it is not to say, as some African scholars contend, that Africa was a place of peace and prosperity, or some will call it a romanticized notion of Hakuna Matata, which colonialism came to disrupt. But it is to make the point that there were challenges, there were difficulties, people's rights were abused, which therefore provoked them to demand for change and therefore led to the development of a culture of human rights. So the point that I want to lay my presentation on is that Africa's international relations practices were partly informed by recognition and respect for human dignity, which was founded on human rights and respect for democratic culture. And this is a premise for developing an African foreign policy, developing the agency in international relations, and contributing to shaping a world order. Shall we then go through the evolution of three constitution-making processes which link up to three world orders that Africa has experienced since the time of independence in the late 50s. At the time of independence, African states were bequeathed with liberal constitutions which more or less were negotiated with the departing colonialists. But in these constitutions were inbuilt measures which were meant to protect the overall economic and strategic interests of the departing colonialists. So we have elements of constitutionalism, civil rights and liberties, multi-party democracy, traditional forms of governance, one way or the other, in these liberal constitutions. However, African leaders soon after taking office rejected these constitutions, and within a period of 2-3 years, by 1962, according to Professor Prempe, about 13 newly independent states had rejected these constitutions because their contention is that the elements in there which Dr. Kwame Nkrumah, our first president, called it schisms and impediments to the attainment of speedy development. So in its place was developed African socialism. And African socialism was supposed to go back to our culture, cultural practices. However, it only introduced a caricatured version of Africa's traditional political systems in the name of African socialism. Time will not allow me to go into the different versions of it, but among the principal features of it are personal dictatorships, military regimes, one-party authoritarian systems, imperial presidency, which led to criminalization of political dissent, and we saw the emergence of neo-patrimonial order in the system. Now, in terms of the relationship between human rights and development, African states were of the view that development would precede human rights, that human rights was a stumbling block to development, and that human rights is a subset of development or a natural byproduct of development. So when you attain development, before naturally human rights will come into place. And so human rights is enjoyed as a result of or as a reward for development. At the same time, we see a situation where because human rights was not given prominence in the constitutions of African states during this period, when they had rejected the liberal democratic orders, constitutions bequeathed to us, there was no space to develop international relations which would have moved Africa from the periphery to the center by individual African states, because the focus was on consolidation of personal power. So if you have a highly personalized and heavily concentrated power in the life president, then his personal attitudes, choices, and decisions would determine the kind of policy which was always inconsistent and were influenced by the Cold War politics of the time. Then came the OAU, which adopted a similar approach by African leaders. So we have a situation where the OAU was organized, that is the Organization of African Unity, which was set up in 1963. That it created an organ which didn't have a distinct will on its own, which was separate from the will of its member states. It therefore could not rise above its members, but remained between its members. And it also didn't have space for human rights and democracy. Kebembe, the father of the African Charter on Human Rights, wrote, and I quote, "Thus, African governments appear clearly to have sacrificed rights and freedoms for the sake of development and political stability. This situation can be explained and even justified." Of course, we know the results of the OAU, the failure of the OAU, and the loss of a whole generation, which, if the proper structures were put in place, Africa would have used the OAU to develop agency in international relations and to develop a Pan-African civilization and identity rooted in human rights and democracy, and to use that as a form of governance that speaks to the needs of its people in contemporary times. The OAU passed away and was replaced by the AU in 2002. And that was into the new world order, which I call the instant democracy, instant capitalism period, where we entered into the post-Cold War phase, and where the Soviet Union more or less relapsed, and it became a unipolar world with the US in control. And the US began to implement its triumphalist capitalist agenda over socialism, which was called market democracy, and which therefore called on, in the context of Africa, its African socialist leaders to transform overnight into liberal democracies and to market economies. So we see a situation where there was a return to multi-party systems, limitation of presidential terms to 2 consecutive terms, in about 67% of the cases in Africa's new constitutions. Then we saw the emergence of mantras such as civil society, NGOs, good governance, rule of law, and so on coming into vogue. And we saw transnational activists, scholarly communities, and social movements helping to build this supposedly unassailable and durable US global hegemony. And that is what Fukuyama was speaking to when he said that all these countries are going to follow the liberal order, and that will create the end of history. So this approach moved us from the negative relationship approach between human rights and development, which I said placed development first and human rights as a byproduct, to the passive relationship between human rights and development. And in this context, it is about the fact that because human rights is key to development, but was neglected, the development agenda or development structure of most African countries became sustainable, unstable, and developed because development was stifled. And so the ruling elite saw that this was an opportunity for them, based on the instant democracy, instant capitalism agenda, to institute cosmetic legal reforms with limited space for some enjoyment of rights by the citizenry in order to appease the disenfranchised among those communities or in these countries, African countries. As a result, in almost every country, and of course, probably all African countries, we have ensemble of rights being recognized in their constitutions, some through bills of rights and so on. Yet rights have not been able to project or advance the cause of the ordinary person or to confront injustices and ensure that people are able to use rights in a positive way to improve their lots. And that is what is meant by the passive relationship. Instituting cosmetic reforms and using that to appease the citizenry, giving them rights but taking them back through clawback clauses and so on. So there was this contradiction in having rights but not able to enforce them. And this has made human rights to fall on hard times in many African countries. And in the end, who are the beneficiaries? The beneficiaries, we can talk about the multinational corporations and African leaders themselves who have benefited a lot from this because they could benefit from a form of governance which is not very structured to improve changes on the ground for the people. So we can recognize AU failure in a number of ways, especially in the context of human rights, when we do a critical check. First, the AU did a good job in joining the ICC, but in the end, it parted ways. And it even is now proposing impunity in the alternative to the ICC that the AU is proposing, which up to now has not taken shape in any serious manner. Then the fact that AU has not been able to implement its non-indifference approach to dealing with cases of serious human rights violations in African countries, as opposed to the non-interference approach which was adopted by the OAU, which therefore gave absolute sovereignty to states and warded states, the OAU off from intervening in human rights violations in their countries. A similar approach or a similar experience is occurring under the AU structure as well. Then we can also talk about democracy. Democracy is failing in a number of African countries. Freedom House, for example, even though it has some problems with its methodological approaches, we can use their statistics in a way. It mentions that only 7 countries in sub-Saharan Africa are now in the free category, and that only 9% of people in sub-Saharan Africa live in free countries, which is very poor. But the most interesting part of it is the third termism situation, where there has been changes in constitutions to allow for third terms to go beyond the 2 terms already agreed in about 67 of the constitutions, 67% of the constitutions, to allow for unlimited terms or a third term by leaders. And the procedures that were adopted to arrive at this goal has always resulted in various transgressions of human rights provisions. So third termism has become in vogue, and the ECOWAS even tried to come up with a law, a treaty to stop it, but unfortunately some leaders opposed it. But we have that in the African Charter on Democracy, Elections and Governance, which has included a 5th element, which is supposed to deal with third termism one way or the other. It says in Article 23.5, any amendment or revision of the Constitution or legal instruments, which is an infringement on the principles of democratic governance of states, will result in or will be considered as unconstitutional changes in government. So this is the state of the AU before COVID struck. And when COVID struck, we have situations where a number of violations of human rights have been orchestrated. There are also a number of countries where, instead of relying on the emergency provisions in their constitutions and going by the international law conditions for regulating derogations of rights during periods of emergency, they rather bypassed the emergency provisions in their constitutions, example being Ghana, to enact new legislation which bypass parliamentary or oversight, and which allowed for broad and intrusive power abuses without any justification and without avenues being opened to seek redress in the courts. So there's also the problem of fetishization of use of artificial intelligence and technology in some countries, which has the propensity to be weaponized and to be used even after in a post-COVID situation. Now, there's a situation where Huntington is talking about a civilizational war. There are others who are also talking about a resource war. But my point is that we may rather be entering into a period where there will be a rights-based war by the downtrodden against the marginalized, because poverty is on the increase. It is projected that 40 to 60 million people are going to extreme poverty this year from the World Bank, and 121 million could be pushed to the brink of starvation. And more people are going to die out of hunger than out of the COVID, according to an Oxfam report titled The Hunger Virus. So we have a situation where refugees, for example, can also not cross borders to seek refuge. And so they are going to remain as internally displaced persons. And this may also be fertile grounds for agitation. So the post-COVID world order, or we don't know how long COVID is going to remain, so it could be a COVID world order. It has come to transform the geopolitical landscape, and it has created a multipolarized world where we have a situation that we can say that things are not going the way US had wanted, and therefore there's therefore going to be a situation where China, which is in pole position to lead or to have a big stay in the evolving post-COVID world order, is going to dominate and control things. And that is where it is important for Africa to shape things up. For example, one scholar has indicated that US global leadership is not only in retreats, but it's unraveling, and the decline is not cyclical, but permanent. And so one scholar gives a true picture of what is going to happen. He says there's going to be a Cold War II, and in this Cold War, it's going to be fought between the US and China. US may not have the economic wherewithal, but it can create problems for China, problems of anarchy, where Ikenberry says there will be hegemonic struggles, power transitions, competition for security, spheres of influence, and reactionary nationalism. Now, in a report by the BBC, it talks about the fact that already the Cold War is shaping up between the US and Canada. Pompeo has promised that US will donate so much aid to Ghana, to Africa to help it. And China has also come with this long list of support mechanisms. And there's two attractions here. One is loan assistance and grants. The other is the fact that China doesn't have any human rights and democracy conditionalities. So President Xi has a tall list. For example, cancellation of interest-free loans, building an African Center for Disease Control, putting up hospitals, and so on and so forth. And on the democracy front, this is what one of their China papers says there's no doubt that the populist multi-party format has failed in the continent. It has not yielded the much desired outcomes. It is high time that leaders of Africa revisited their political constructions and formulate one that is underpinned by ideologies and development-oriented policies like the Chinese People's Party does. So we see a situation where there are exit options. We are not just going by maybe the US format, but China is opening an alternative route with alternative patrons and institutions. And this is appealing to weaker states. And we have many of these in Africa. But if we have to go this way, then it's going to spell our doom. Fortunately, at least in the AU Agenda 2063, it mentions a number of attempts to move Africa from the global marginality and lack of agency to the center, at least somehow to the center. So Agenda 2063 talks about the fact that Africa will be transformed into a global powerhouse. The 21st century is Africa's century. Africa will be a dynamic force in the international arena, and so on and so forth. But the question is, how is Africa going to reach this goal and targets? First of all, Africa has to move from the relationship between human rights and development, which we have now, to a positive relationship approach, which places human rights before development. And this is going to conflict with China's position on human rights and democracy. But rights should be the key to unlocking the barriers to development. Rights should be able to protect the gains of development and to institute redress for violations of the rights of the gains of development. The African Charter on Human and People's Rights is also important that there has to be some changes in there. For example, to allow for individual cases not to be subject to the declaration clause in Article 34.6. There's also the need for an alternative form of democracy. I'm arguing that the third-termism approach, African socialism and so on, identifies that African leaders want long periods of power. So we should have a form of governance where when elections are held, they are held about every 10 years. And there is this form of presidential council where if a party wins about 5% of the votes, it's allowed to form part of a rotational presidential council system. Then we should have a technocratic form of governance. Instead of ministers being appointed by the leading party, or the governing party. It should rather be an open bid where people advertise for such positions. Proportional representation should also be encouraged. I know my time is up, so I'll round up in a minute by also saying that we should give special place for civil society organizations. It should not just be the civil society as apolitical institutions. As one scholar puts it, Vinieska, she says, today the idea of a civil society has run out of juice. It does not fit the zeitgeist. It is time to write about the political term in civil society. So finally, I want to say that democratization of the AU will bring greater legitimacy to the organization, and it will promote multifaceted agency. That is harnessing the creativity and innovation of the continent's non-state actors to allow the exertion of more African agency. Because if you open up the space, non-governmental organizations, individuals, and so on are going to help improve our access to sources in international law and international relations. And that is what democracy will bring to us. And therefore, it will not be the dictate of only our leaders. And that will help us to attain what we may call soft power, which rests on three sources: culture, political values, and foreign policies. Thank you very much.
Ladies and gentlemen, Professor Kwadwo reminds us or provokes us of the need to forge an African identity of governance and human rights. Thank you, Prof, for that very thought-provoking presentation. May I now welcome Professor Abuya.
Thank you, moderator. Thank you, Professor Kwadwo, for some very interesting sentiments there. I'm going to pick on your point on rights being the key to unlocking barriers, and the barriers that you were talking about were more in development. So I'm gonna pick it and situate it in a particular context within also a particular cohort of individuals. And my lecture today is going to focus on learners with disabilities. As you know, there are many disabilities. So for the purposes of this lecture, I'm only going to focus on the learners who have physical disabilities. Now, when I stand in the first title, I was advised that one of the things that the lecture Julius Osega focuses on are matters of governance. So I had to go and cobble something that would be close to the ideals of this lecture. And so that is the title of my work is Governance in Universities, with a focus on the extent to which rights of learners with disabilities are embraced within these institutions. Now, first of all, I want to just to discuss a little bit on what is governance, so that I know my colleague has gone on and talked about the AU, the OAU in that particular context. And in very simple terms, I got some definitions from both Africans and non-African writers. And the bottom line that they're talking about is the effective implementation of policy. So whatever policy, it's either state policy, it's by a private institution, it's by a public institution. The question that governance asks is, to what extent are we implementing effectively the policy at hand? Then a bit of research on governance, because the lecture, the sense that I got is I had to bring in some up my game on this lecture. And so I looked at a bit more research on governance. Where did the word governance come from? And I located some Greek writings which talked about governance. And what they say is the word governance in English came from the Greek word. That's again debatable. But in the Greek sense, governance, the Greek equivalent of governance means to steer a ship. So the word is kubernan, I think it's easier than some of the names that I'm seeing pronounced in terms of pronunciation. It's spelled Kuberanan. And the word there, as I said, means how to steer a ship. So I'm going to look, so in other words, the word governance brings the thought of you're a part of the ship. Either you're the captain, either you're the guys in the control room, you're the guys on the underground, under the ship, whatever you're doing. But the idea here is that how we are going to steer this ship. And so when we steer a ship, there's always one person who is the leader, and that leader then guides the rest. So based on that, I'm going to look at now to what extent do our and I'm going to ask you a few questions, so you have to reflect on your institution in terms of how is your institutional quote unquote ship being steered. Now, just a bit of background, whatever I'm going to discuss is a joint paper that I'm doing with a colleague of mine, and it's looking at, it was a project that we're looking at learners with disabilities in institutions, but for this lecture, I'm only focusing on folks with physical disabilities. And so in terms of the guiding framework, and I think my colleague talked a lot about that, the guiding framework, or the starting point, we have the international laws, the Convention on the Rights of Persons with Disability. We have the international legal framework, which Professor Mwaura was talking about earlier on, the UDHR. And we also have, as you cascade it downwards, we have regional laws that seek to protect learners with disabilities generally. And then we also have statutes that govern different universities. And I would imagine that in your setup also, there would be a statute, either a specific statute that governs your university, or a general statute that governs, that regulates the university systems in your country. And in some countries, it goes deeper in the sense that some have specific legislation that govern private universities, and other legislations that govern public universities. And in some, it is one piece of legislation for all. We also have constitutions that talk about the rights of persons with disabilities as a specific group, but in addition to that, there is also the additional layer of the anti-discrimination provisions, dignity provisions, provisions on right to education, and so all those I can say are the main, the broad band, the broad width of the regulatory framework, if you like, that talks about access to university education. So there's a point about access to education for everybody, and then there's specific provisions on access to education for learners with physical disabilities. Now, so let's go down to asking ourselves, how is this ship being steered? Now, as I go on to to talk about some of these sub issues, and we will come to the Q&A, I would like you to reflect on your institution. It will be, maybe it is a public institution, it's a private institution, it could be an academic institution, but it could also be a non-academic institution. So some of the factors that I'm going to pull out may not be relevant to you, or they may be relevant in terms of perhaps you're a professor in a school, you're a student, or wherever you work, just a personal reflection. The first factor that I would like to ask you as you you look inward is, what are the admission requirements in your institution, particularly for the ones who are in academic settings. Yesterday, I attended a talk, and one of the discussants was discussing, it was about a report that was done in Kenya at my university about the extent to which it is inclusive in terms of learners with disabilities, so the broadband again. And one of the comments was about that the points that the grade, or the points that learners with disabilities come into the university should be reduced. So if the cutoff is, say, 60 points for learners with disability, we should knock them down. And there was a big discussion on that aspect, on whether that makes sense, on whether it is again going to discriminate on the others, and etc. And that is an ongoing debate. The question that I want to ask you is your university conducive enough to attract learners with disability? Because there's a lot of research out there that shows that learners with disability select institutions on the basis upon which they are quote unquote disability friendly. So if your institution has the requisite is disability friendly, then there are high chances that your institution will attract this cohort. And that explains why for a long time, certain universities in Kenya got very, very few learners with disabilities. And in our research, we found some of the people we talk with say that, look, I went to this particular university because I was told that it is more friendly to persons with disabilities as opposed to University X. And when you go to the ground, you discover some of those nuances play out. So to what extent, and the extent to which your university then would embrace learners with disabilities has an impact on who applies to your university, and how, whether or not once they come on board, they're actually able to complete their education. So it's the facilities that are on the ground, either from word of mouth or in reality, determine the extent to which persons come in or they don't come in. So that is one of the first barriers that learners with disabilities experience. The next port of call is on matters relating to access to classrooms, access to offices, and access to the hostels, particularly if your university provides accommodation for students. Now, in a number of institutions now, you will find ramps as a mode of access to classrooms. You will also find lifts in some, and I'll talk about that, yeah? Now, the issue about this particular access is that some of the ramps that you find in some of the institutions, and this again comes from when you read a lot of literature around this area, you find that those ramps were built without consulting first the learners with physical disabilities. So the able-bodied person imagined that then we should build ramps on this side so as to be compliant with the law, which is perhaps the first step that you'd expect one to do. But the problem is that some of those ramps, they're either too steep or they're either too steep for one to go down or to come up with, particularly for the folks who use wheelchairs. And so it questions really whether whether the ramps that we have in some of our institutions comply or do not comply. And again, perhaps in the Q&A, you'll be able to share some of the insights from your institutions. And there's a common disability saying that nothing about us without us, so that whatever you are doing, you have to consult the learners with disability, in this case, in the university setting. Point number 2 is on location of offices. A couple of days ago, as I was researching for this talk, I came across a very interesting article where some of the learners with disability were saying that the disability office is located on the second floor of building X. And so they said, fine, it was very good that we actually have now a disability office. But then the question is, how do we access that office? The building itself was an old building. So it brought in issues about how learners with physical disabilities would be able to access that particular building. Now, in some instances, lifts have been constructed, and you know, in some of your institutions, you have lifts, but in others, particularly the old buildings or even the new buildings, you find lifts, but the lifts are not big enough to fit some of the, particularly the folks who use mobility tools. So the lift is too small. And in one of the universities that we sampled in this study, there was a building was constructed, the lift shaft was put in. Then when they came to try to fit the lift, they found that the lift was too big for the shaft. And so what did they do? They put the lift aside.
seem to have lost Professor Abuya. Professor Abuya, can you hear us? Let's give him a minute to see whether we will get him back. Professor Abuya? Right, as we try to wait for him, may I request that at this point, if you have any questions, please continue writing them on the chat. I can see Professor Abuya is back. Welcome back, Prof. Please continue.
Oh, thank you. I'm sorry, I lost my connection for about 30 seconds. Yeah. And so the question then is I was giving you the narrative about the old building, the new building with a shaft, but the shaft was so big that the lift could not fit. So when they went back to the contractor said, yeah, but I've not been paid, so how do you expect me to come and fit the lift or to even to work on the shaft? So this back and forth took about 6 or 8 months. I understand it was resolved, but again, it was resolved in a very interesting way because the lifts are only work at certain times. So again, creating barriers. The other issue is on the access to the offices. And now what we found is that for offices that are located or not on the ground floor but higher up, there are two choices that folks with learners with physical disabilities have. If a building, so they would either access it using the lifts or the lifts in particular. But if the building did not have lifts, then some of them would wait at the bottom of the building and find somebody who was going, say, to level 2 or level 3, and ask if that person would be able to call person X from the office. Now, that you can imagine how problematic that is, the legal issues, the human rights issues that it raises, issues about dignity, questions about the time that is lost. And if somebody was not willing to go up the lift with you, to go and call person X for you, you can imagine how much what a student or a learner would lose in that context. Now, the other aspect that is concerning as we talk about access relates to transportation within the university. And again, I want you to reflect on your university, whether the university provides inter-campus transportation. In some institutions that there is inter-campus transportation for persons with learners with physical disabilities. And so that is very, very useful to them in terms of reaching the spaces that they want to reach within the institution. It also acts as provides security. And remember, Franz was talking about Julius Osega and questions about security. And it also ensures that learners with physical disability are either to get to class on time. So places where these facilities are provided, that is good enough. But what about in places where none of these facilities are provided? And that's super, super problematic. And what we found is the students then, they have to make a choice. Either they will, either they'll come to class and sit in for the morning classes, and then if they have a class in the afternoon or so, they'll choose not to come to those classes simply because the trips up and down from their hostel is too much for them. Others just decide that, look, because the classrooms or I can't gain access, I'm just going to discontinue my studies and look for an alternative institution or somewhere else where I can make things work. So again, that comes up to the questions about the kind of courses that they can pursue. Library access, we also found as a governance issue, is also problematic, particularly where you find libraries now. Most of them will have the ramps, but I've talked about the issue about the ramps. Now, there are certain materials, especially for some of the buildings that were built, the old buildings, let me just call them that, which have basement spaces. Now, in those basement spaces, the only way to access them is via a staircase. So so in other words, folks who are on wheelchairs, folks who have problems, physical disabilities, it will be very, very difficult for them to go to the basement. And so, even if not only the basement, but if your library does not have a lift, then it becomes extremely difficult for somebody with a physical disability to move from the ground floor to the upper level. And I know there are many, I've visited quite a number of universities, and I see the same trend in terms of access to the library. And so then now perhaps but in the situation that we are in now, this COVID situation where the institutions are closed, then we can see that in terms of access to the library now, most students have to access the library only via the online sources. So in a way, the physical library is sort of no longer relevant. But again, from the question is whether the folks with physical disabilities, even in a COVID situation like we are in, are able to access the electronic libraries. Again, it would just be interesting to hear your take on that. The last factor that I want you also to take a bit of retrospect is on the examination arrangements. When I was an undergrad many years ago, there was one of my colleagues, and this is not in the area of disability, but this is just, he was left-handed, and most of the desks that we had were for right-handed people. So for him to write the exams or even to take down notes, those days lecturers used to just dictate notes, he had to combine two desks side by side. So one he would use to put his hand, and then the other one he uses to write. So when it came to the examination, he had to have, he needed more time than the rest of the people who are right-handed. So that's for a person who is an able-bodied person. So for the learners with disabilities, the question is, are there any support systems that your institution has put in place to enable them to, first of all, to access, to write exams, and also to write exams in a way that will put them at the same level as abled, the folks without disability, able-bodied students. And these support systems come in many ways. So what we've found is in a number of institutions, and let me talk about my institution and in the courses that I teach, that it's only when you know that a student has a particular disability that then you can either, you can give them more time, or you ask them for what tools that they would need. And so if that information doesn't come up to you, then it becomes extremely difficult to know which examination arrangements can you put in place in order to accommodate the learners with disabilities. So again, it'd be interesting to hear what your sense is. I remember one year when I had a student who had a disability, and it was quite, the first couple of classes were very interesting. They're very problematic because the ramp that I mentioned was very steep. So this gentleman had, to a certain point, had to be helped by other students in order to come down to the classroom. So it was very concerning. So when you go to the examination period, we decided with the other co-lecturers just to give the gentleman sufficient time to write his exam. But that again is on a need-by basis. So let me come now to what I call the three-legged stool on. So the ship has sailed. The ship has found all these problems: the admission requirement, access to classrooms, and library access, as well as problems relating to examination. So what are some of the steps that can be taken in order to ensure that the ship gets across to the other side of the shore? Or how do we combat the storm? The first strategy that can be taken is resource mobilization and utilization. Now, from my experience dealing with institutions, public institutions in particular, there's a common saying that, you know, the budget has closed. The budget was passed yesterday, but when you come to DIP, you come in with an application for funding for X, you're told the budget has closed. Now, but again, we recognize that or the budget has either closed, so you didn't pitch in early enough to bring your request, or in the alternative, the budget is overspent, so i.e. there's no money. Resources are finite, and that is sometimes realistic. Sometimes you wonder whether the standard statement is we don't have money as a running statement. Now, apart from some universities that I visited in America, and I was surprised that how much budget lines they have for item X, item Y, and item Z, and I thought, wow, if only we had like a tenth of that budget. But anyway, let me come back to my talk conversation. The Kenyan Constitution is now very, very emphatic on the questions about budgets, because institutions will try and use the lack of resources as an excuse. And so the Kenyan Constitution places a burden on public-private universities to explain. So yes, you can say that, look, we don't have resources for perhaps to put a ramp, or to improve on the lift, or to hire the subcontractor to come and finish the job, or to relocate the office, whatever it be. The Constitution places an obligation on the duty bearer to demonstrate how they have utilized that particular resource. So it's no longer sufficient just to say that, look, we don't have resources. The High Court of Kenya has gone even further to say that blunt statements cannot work. You have to go down to the very, very basic level and say that, look, this is how we spend, this is the budget, total budget line, this is the budget that we have for learners with disabilities, and scale it down for different categories of disabilities. The blind students, the people with psychosocial, and the people with physical disabilities. And then even within the context of the physical disabilities, you must categorize the different levels that you are attending to. Now, there's some authors who said in the initial writers in the 2000 or the late 90s, they argued that no, universities will never want to open their budgets. So if there's any problem about financing, they will come on board and support the programs. 20 years later, we are seeing that's just not happening. And so one of the things also, remember I talked about the main mantra in disability, that nothing about us without us, that for anything that you're talking about, you have to include learners with disabilities. So it's very important now, and you can think back in your institution, whether when budgets are drawn, there's an inclusive process, or it's a process that only involves the bureaucrats. The bureaucrats up there are the ones who draw the budget and decide that these programs you're going to give X, this program you're going to give Y. But the inclusive budgets literature shows that the more you include these different cohorts into the formulation of the budget, then even the bureaucrats start getting to understand that actually there's a lot of benefit in this inclusion process as opposed to having an exclusive process. The second leg to the stool, remember I talked about the three-legged stool, is part of the strategy is advocacy, or what you call education campaigns or education schemes. Now, there is an argument that we should not expect the learners with disability to be the ones who come to the forefront to sort of explain their plight or explain the kind of issues that they have. But I think from the research that I've done, that argument does not really hold a lot of water, because the reason why we do these advocacy campaigns is so that we can create knowledge about the entitlements. And remember what my Professor Kwadwo talked about, that rights are a key to unlocking the barriers. So we need to know what is it that person X needs, what are the special arrangements that person X needs. Number two, these information campaigns or the public education or the advocacy campaigns, they also tell us about the competencies, so that we don't only look at persons with learners with disabilities as a drain, but also that they are part of the student community and they have also a lot to offer. They also, the information campaigns or advocacy also creates liability, so that you know that if I don't do X, then there is Y that is that is coming up. And in the example that I gave about the lift and the shaft, one judicial officer visited that building, and after that he called me and said, but you know, this building is just not working, yeah? And he said, I wish somebody would actually bring a claim where the court can then give an order compelling the institution to take certain measures. So you can see, in the absence of that information, then issues surrounding liability are very difficult. And there's a very good Hong Kong case which draws that connection between information and liability. And what the court here was emphasizing is that as a person, as a student with a disability, physical disability or any other disability, it's important for you to come forth. Otherwise, in the absence of that information, then it's going to be tough for the institution. Although, of course, there's also the side that the institution has an obligation to collect that particular data. The last point on about the need for the public education is a case that came from the High Court of Australia, which talked about advocacy is a powerful tool for also changing attitude, that people have different attitudes about X, Y, and Z. And so with advocacy or public education, you can start to check some of those prejudices that arise. Now, you know, one of the strategies that we found that are used in certain institutions are what you call the open days. And so during the open days, able-bodied students are put in situations to sort of the situations that learners with disabilities face. So perhaps you'll be put on a wheelchair, you'll be given a pair of crutches to walk with, whatever it be. And the data that comes from the information that comes from this research is that these sort of open days are beneficial. So you get learners with disabilities that say that, yeah, put them in the same situation, and perhaps using that they will be able to know what it means to sort of have go on a wheelchair on a ramp that is very, very steep, or to go up 3 flights of stairs using maybe a walking stick, or using a pair of crutches. So there is that body of law, a body of knowledge that talks about the benefits of open days. But there are other authors who say that, look, these open days, they just don't work. There is no way that an able-bodied person will fit into the shoes of a learner with disability. And so to an extent, that argument makes sense, that you can't 100% fit into those shoes. However, the open days, the trouble that I have with this argument that it just doesn't work is that argument doesn't draw on any evidence. It's what you call the very weak arguments. Yeah, there's no support, there's no empirical data that it draws on, and it's a very blunt statement that talks about that. Now there's the research that is out there shows that these experiences are very, very useful. So, for example, there's a case in Kenya where the court was taken by the litigants around the courtroom, just to say, to make the point about the courtroom not being disability friendly. And so after that experience, when you read through the finding of the court, you find the court actually talking about how much it appreciated that experience. So in many, the court finally went and made a decision that I think some of the parties were not happy with. But the point here is the value of those experiences. The third stool is the one on what is normally referred to as reasonable accommodation. And the reasonable accommodation essentially is just the steps that you can take to meet the needs, the special needs of learners with disabilities. Now, Professor Kwadwo will know about I would imagine, the Eaton case that was decided by the Canadian Supreme Court. So AfricanGovernance made a very, very powerful statement on taking into account the special needs of learners with disability in the measures that you take. Now, but the trouble with this statement about reasonable accommodation, remember, not the word here is reasonable accommodation. So an institution can come and say that, fine, we really, really want to install that particular measure that you're talking about, whatever it is, we really want to do it. But you know what? In the guiding principle here is reasonable accommodation. And so the excuse that most institutions would then draw is that it creates a very heavy burden on us. And that is the legal test that has been used. Now, another very good Canadian case, which was decided by the Supreme Court, says that the fact that we use the word reasonable accommodation does not mean that a duty bearer's latitude is unlimited. Say that actually it's the converse, that in whatever you do, we are just using that word reasonable accommodation, but we are telling you that you need to think through the adjusting your systems, and so your latitude in terms of what you do is actually limited. It's not the reverse. So to go further than that is that in Australia and also in the United States, the Australians, they have the Disability Discrimination Act, and also some of you may have heard about the Americans with Disabilities Act. What these two statutes have done, rather than have long litigation about what is the reasonable accommodation, at what point can you use the excuse of undue hardship, that's the operational word in most of these statutes, is they've come up with a checklist. And they say that for you to determine whether a particular initiative will cause you undue hardship, these are the factors that you have to consider. Now, these two statutes by any means are not applicable to our countries, but they help us in terms of addressing, keeping us in check in terms of what are some of the things that we are supposed to look out for to determine whether or not factor F is unreasonable or factor Y will testing the extent to which the measures that we have taken are compliant. So in conclusion, as we get now, remember you are steering a ship, so you are just about to get to the shore. Now, the disability rights, learning within, education in the disability circles has gone a long way for persons with disabilities. Long time ago, they used to be kept in the hidden spaces. So they would never be brought out, never be taken to school. And so that in itself had an effect on their learning and also on their prospects in future. Now, so the hidden spaces now, persons with disability, as data shows, have been brought up to the forefront. Now, the question then is whether countries are complying with the treaties that they sign up to. So many of the law students would know that under the Vienna Convention, you have to implement the treaties bona fides, and so in good faith. And so the question comes in, even you, as you reflect on your institution, is your institution actually doing the implementation in good faith? In one of the problems that we have in Kenya is that the building code that is operational now is the 1969 building code. And so in terms of compliance, I think now it's generally accepted that you have to comply with the but the building, the building code in itself, owing to its age, can also be an excuse as a pullback measure for
Sorry, we have lost Professor Abuya again, but we'll give him a minute to come back and conclude. I have seen a couple of questions on the chat, so thank you for that. As we wait for him, please carry on writing your questions. And perhaps as we wait for him, I could share the question that is addressed to Professor Kwadwo, saying that my question goes to probe the notion of either or when it comes to the issue of human rights and development in Africa. Even with a very valid concept of the African third world marginalization in the international community, how practical is it to focus on human rights where countries do not have the infrastructural capacity to protect them? So I can see Professor Abuya is back. Professor Abuya, can you hear us?
Yes, I'm here. Sorry, I'm here.
Please proceed. I was just raising a question, but please proceed.
I think what I was saying is that I am done with. I don't know did I get cut off again?
Yes, towards the very end, just in conclusion.
Okay, so
the last minute or so.
Oh, just the last minute. Okay, I'll go back to the last 30 seconds. What I was talking about is about the building code, yeah? And the kind of frustrations that the building code can have in terms of compliance. So we have a very old building code. They have talked about repealing it. There's some, I think there are several steps to come up to the point where the building code should be repealed. But the point I was making is that in the absence of current protocols or current legislative builders will come up with now generally accepted. Okay, sorry, Chair, I think I'm done.
Thank you very much, Professor Abuya, and particularly for reminding us that we need to give learners with disability agency. You remind us that nothing about us without us. And I think what's profound is concluding with a strategy, because often we just think of the issues and don't come up with a way of addressing them. So thank you for the thoughts about the three-legged stool and on what needs to be done to ensure inclusiveness for learners with disability. So with that, ladies and gentlemen, allow me to go back to the questions that you have already written. And I had just read one to Professor Kwadwo on the question of either or when it comes to the issue of human rights and development in Africa? Is it either or? And how practical is it to focus on human rights where countries do not have the infrastructural capacity to protect them? Allow me, Professor Abuya and Professor Kwadwo, to just read the questions, and then as you think about them, we could come back to you. There is another question. This again was from Chinyere saying, I would like you to talk a little on inclusive education for children or students with disabilities as a human right in line with international laws. That is again to Professor Kwadwo, that African countries do not see the need to make our schools disability friendly as to imbibe inclusive education. What is your take? Just checking whether there is another question. Perhaps we could start with that. Professor Kwadwo, please.
Thank you very much. The question is interesting, but I think the second question you said is directed to me, rather for Professor Abuya. It's on disability, even though yes, I can chip in some comments on that as well. But I think it is not an either or situation. But the point we need to note is that if we have a blank slate, there's no development at all, and we need to attain development. The question is, how are we going to attain that development? You need to sit down, look at the needs of the community, look at their capacities, and then determine that based on your capacities and the needs of the community, each person can chip in this and that to be able to clear the path, build a road, provide some food, and so on. So in that case, the question is, how do you give capacity to these people? In the first place, you have exercised some human rights by asking this question about need and capacities. You are exercising the freedom of expression, freedom of association, and so on. And then the capacity, how do you build a capacity to be able to build a road, for example? Somebody has to go to school. So you are moving from, you are talking about the right to be able to attain a certain status. Before you can reach the status of right to do, to be able to do something. And then you get to right to have, where you're able to acquire property as a result of the effort you have put in. So that tells you that between the two, it's the rights that will lead to the development. And so where you try to push rights away and say that we don't have infrastructure, so how can we talk about development rights? There are a lot of the rights that we enjoy. We don't need a peso or a penny or a dollar to be able to enjoy them. So this is where we start from before we talk about rights in the context of maybe economic, social, and cultural rights. So in that context, rights are pivotal and the gateway to breaking the barriers to attaining development. If you are looking at, for example, the Chinese situation and say that, oh, but they have developed without human rights, then you are talking about a situation where some people are being compelled or forced to do certain activities in order to maintain that system. And so where you have space where people are freely given the opportunity to determine involved in the decision-making process, that's, you are able to build a system or a kind of development that is sustainable. And that is what I'm proposing or postulating in my presentation here.
Thank you, Professor Kwadwo. Before I get to Professor Abuya, perhaps allow me to read the other question, which is also for you, Professor Abuya, so that you can deal with both of them. A question here is, what about university accommodation for learners with disability who come from distant places? Is this on the university's authorities' radar? Professor Abuya, please. Sorry, Prof, you're still muted, I think.
I'm sorry. Yeah, I had the second question. Do you want me to take them now?
Yes, please.
Dr. Kinyanjui, shall I go?
Yeah, I think Sarah can't hear. I think she had mentioned that you can actually go ahead.
Can I go ahead?
Yeah, kindly do.
Okay, sorry. Where am I? I don't know, my network is a bit imperfect. So there were two questions. There was one about children and the levels or the extent of their inclusion. Now, I don't know the name of the person who asked, but the point here is that, if you look at the literature that is out there seems to be, initially there was a lot of focus on children with disabilities. So the literature focused a lot on primary schools and secondary schools, and it is only now that we are starting the conversation about students who are coming to universities, learners with disabilities. And so because of the focus initially on primary school and high school, then you can say that to a certain extent, the amount of focus that has been put there has attracted sufficient resources to try and make some of those spaces disability friendly. But still, when you go down to the ground, you find a lot of disconnect, yeah? And so our focus in this study was not so much on the children or the young people who are still on the lower levels. However, we looked more at the university, which is sort of an under-researched area. And also, when you look at the situation in the universities, it seems as if at that level, they have a bit of autonomy. They can make their decisions on quite a number of things, unlike the young ones down there. So our focus was mostly on this tail end of the discussion and not on the lower side. But I can tell you that there are still quite a number of violations at that level. In terms of the responsibility of the universities for students, the students who are not on campus, that was the question.
Including those on campus, the whole aspect of accommodation, what extent does the university responsibility extend to?
Okay, now if you look at the university statutes, they would only talk about they only talk about their responsibilities within the institutions, yeah? And I would imagine that then out of the university, then the point would be there's somebody else who has to pick that, pick the tab. And so perhaps the question is, how then do we deal with the people, the students who say reside out of the university? Because on-campus university in many Kenya university as for the government-sponsored students. So what about the ones who are not accommodated on campus? Is there any responsibility on that? I would imagine that it would be a stretch to try and bring the university on board liability, say for the ones who use public transportation, because that then, in terms of liability, has to be picked by another player. But that doesn't mean, remember that second stool that I talked about was issues about advocacy. And so in terms of advocacy, that means that the university then has a wider obligation in terms of reaching out to the other sectors that are not within the university strictly so-called, but that have an impact on the learning process. So my answer, you get, it is in terms of nailing down the obligation. I think the issue is what else can the university do in terms of creating awareness on the other players out there. And that would be my take on those two questions. Thank you.
Yeah, thank you, Prof. And to Professor Kwadwo, related to COVID, the question is, what is the impact of COVID-19 on social order, and what criteria, if any, can the government employ to guide itself on the emergency action?
Sorry, can you repeat the question, please?
What is the impact of COVID-19 on social order, and what criteria, if any, can the government employ to guide itself on the emergency action?
Okay. Certainly, COVID has made a huge impact on social order and consequently on the enjoyment of certain rights. For example, freedom of expression, even that case is quite not as huge as freedom of movement in particular, and also freedom of association, freedom of assembly, and so on. Because if all these rights are not properly controlled and regulated, it can lead to the spread of the disease. And so what needs to be done by governments as a guide is simply, first of all, to go to the derogation clauses as we find in the ICCPR, the International Covenant on Civil and Political Rights. That is the first point of call. And over there, then we'll be able to see that there are certain rights that cannot be derogated from. But of course, these rights or freedom that I've mentioned can be derogated from during such periods of emergency. However, we need to, particularly in the context of the COVID that we're talking about, we need to look at it in the context of not having a severe impact on social life and consequently, or by extension, on economic life. We know how the lockdown impacted on so many communities to the extent that even in the High Court in Malawi prevented the government from implementing lockdown because of the fact that many people live on hand-to-mouth basis, and therefore the lockdown without any provision of certain social facilities or interventions could even lead to serious impact on their lives. So there is a need to ensure that rights are limited in their enjoyment around this time in order to control the spread of the virus. But it has to be guided in such a way that it doesn't lead to other rights violations, such as even the right to life and right to health. Thank you.
So thank you very much, Professor Kwadwo, for that. Ladies and gentlemen, we are coming to the end of this very, very interesting session with quite some thought-provoking discussions. May I now take this opportunity to hand over to Professor Mwaura of the School of Law, University of Nairobi, to give some vote of thanks. Professor Mwaura, please.
Can I just ask a question?
Yes, yes, please, Prof.
Just in terms of COVID, and we know that now we're operating what we call the new normal. The question is, to what extent has your institution included learners with disabilities in terms of charting the way forward on how teaching and examination is going to be done? Thank you.
Interesting thought, Professor Kwadwo.
Thank you. So if I got the question right, you're asking what measures the UN has put in place, or you're asking about what each government has done or could do?
Just your institution. Your institution.
Unfortunately, I have that area. However, looking at what, in the case of Ghana, for example, what the government has done is to make sure that students are able to do online studies and write their exams online. However, at the University of Ghana, for example, we also recognize the fact that there could be persons with disability who may not access such facilities. There could also even be persons without disability, but who may also have difficulty accessing the internet, or may not even have a laptop at all. So the university gave room for students with such needs, including persons with disability, to come to the campus for, I think, three weeks to a month or so, to be able to catch up on their studies, either through whatever means that the lecturer may arrange with them, so that they will be able to be at par with their colleagues who did their studies online before they will write their exams.
Right.
Thank you.
Right. Yes, Professor Mwaura, please.
Thank you so much, Dr. Sarah Kwadwo-Appiagyei. I also reckon that at the University of Nairobi, just like Professor Abuya was asking, we have also taken similar measures where we are saying that for students who are not able to attend classes, we are trying as much as possible not to be very rigid in terms of penalizing them for not attending the live sessions. And so we are providing as well recordings of any lecture that we do, so that any person who is not able to actually attend the class online, they can follow the recordings, and they can actually do the exams using those recordings. So we are taking those measures to try as much as possible to be inclusive. So to give a vote of thanks, I wish to thank the presenters of today's lecture, Professor Kwadwo and Professor Edwin Abuya, as well as the moderator, for a job well done. We have learned a lot from your insights. And I also wish to thank the Center for Human Rights of the University of Pretoria for hosting us virtually and for instituting the annual memorial lecture in honor of Julius Osega, whose values shall continue to inspire the human rights training and work that we undertake. We also truly value the participation of everyone who was able to join us this afternoon, and we thank you for taking part in what was a very insightful lecture. Your input has greatly enhanced the quality of the debate that we have had, and we look forward to your participation in our future events. We wish you a very good day, and thank you for joining us.
Thank you very much, Professor Mwaura, for that. May I now request Dr. Bassett for the final word. Dr. Bassett, please. Whether Dr. Bassett is still with us.
Yes. Do you hear me now?
Yes. Yes, we can. Thank you.
Okay, thank you so much. Let me also, on behalf of the School of Law, University of Ghana, and on behalf of our Dean, express our appreciation to all those who have participated in this lecture. As I've said, it's a very insightful lecture, and our hope is that the spirit of human rights will live on and influence whatever we do on our continent for the betterment and welfare of our people. On that note, thank you so much for making us part of this program, and we wish everybody a good day.
Thank you, Dr. Bassett, for that. May I take this opportunity to thank you, participants, and just echo the sentiments, and thank you for having stayed throughout. We have been provoked, and as scholars, as civil society, we have thinking to do. So thank you, presenters, for that very insightful session. May I take this opportunity now to say that we have come to the end of this session, and you're free to leave at your own leisure. Thank you.
Thank you.
Thank you.
Bye-bye. Thank
Bye.
you.
Bye-bye.
Colleagues, keep well.
Bye-bye.
Bye.
Bye-bye, Edwin.
Bye, 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 bye.
Well done.
Bye.